Hey, everybody. I hope you can hear me okay. For those of us that are here live, and for those who will be joining us, I know we have a lot of people that are not able to be here for this live because it is number one Father's Day. So very happy Father's Day to all of the fathers out there. And we also want to say hello to everyone who's going to be watching us on repeat. I've gotten several messages from some of the followers of the podcast, which is on Amazon, Spotify, it's on iHeartRadio, it's on probably about, I think, a dozen different platforms in addition to YouTube. And so I want to say hello to them because I know it's tomorrow for some people, literally. They have to come back to the future in order to join us. But it's Kathy. I want to welcome you to, this is really just our fourth live that we have ever done. We don't do a lot of lives. We really just do them when things are important. And when I scheduled this live about 5 weeks ago, right after the final pretrial conference, when we knew that there was going to be a hearing on the 18th of June on the offers of proof regarding alternate perpetrators, little could I have imagined all of the things that would have happened between just the time of the final pretrial conference and today, as we inch our way towards Voir Dire, which is coming up very soon, end of July, and we'll be heading towards trial in this case unless Judge Hippler grants a motion this coming Wednesday, which is the motion to continue. So I see that we have quite a few people in chat. I want to say hello to everybody collectively who is in chat today. I see some familiar names. Thank you so much for joining us here live today. I want to really just jump right into it because we're all about the documents. We're no nonsense. We deal with the public record. And a big shout out to the state of Idaho Judicial Branch for giving us the gift of the public record on the case, because otherwise, if we didn't have that webpage, Judicial Interest, Idaho Cases of Judicial Interest, where the entire docket and case summary page, which is 99 pages, is now, we'd have to go to two different places. I know it's definitely saved me a lot of time, especially with the podcast. So as we look toward Wednesday with two extraordinarily important hearings, game changers, both of them potentially, I wanted to just take a few minutes to do what's called procedural posture, which is to give a summary of the overview of the case until now briefly, because that case summary page, 99 pages, there are hundreds of documents, but I want to just go over some of the key events that brings this case toward the 18th of June in these two very important hearings. And I'm going to refer to my notes right now. November 13th, 2022 is a day that we have to look at as being a extremely sad day when some catastrophic events occurred at 1122 King Road in a little town called Moscow in Latah County, Idaho. And on that day, someone's at the front door doorbell. Someone's at the front door doorbell. Okay, we're going to just ignore them for right now and say that on 1122 King Road, back on November 13th, 2022, there was a truly catastrophic event that happened. 4 young people who we must always remember: Madison, Kaylee, Xana, and Ethan, were found unalived in what just sounds like the most difficult and horrendous manner that one could imagine. And we are here, this channel exists and that podcast exists in their memory and in search for the truth of what happened that day at 1122 King Road. Who was responsible, and hopefully why did it happen in their names and in their memory. We then fast forward approximately 6.5 weeks later. On December 29th, 2022, there are 4 very important documents that you can find on the docket. Number 1 is the 18-page affidavit of probable cause that was signed by Detective Brett Payne of the Moscow Police Department. And it starts with his arrival at 1122 King Road with his colleague, Sergeant Blacker, also of the Moscow Police Department. And it ends at page 18, where he is asking for a warrant for the arrest of Bryan C. Kohberger. And at this time, we must always remember that Mr. Kohberger is considered not guilty of these 5 very serious crimes that he has been charged with, until or unless one of 2 things happens. He pleads guilty, or he is adjudicated guilty by that future jury at trial in this capital case. Also on the 29th of December, just want to back up things. Affidavit of probable cause, also called the PCA, Detective Brett Payne, asking for his warrant for the arrest of Bryan C. Kohberger. Then there was the criminal complaint that was sworn out by Bill Thompson, the Latah County prosecutor. 5 counts. First-degree burglary with the intention to commit the unalivings that followed. Count 2, Madison. Count 3, Kaylee. Count 4, Xana. Count 5, Ethan. Also on the 29th, we then see the order finding probable cause that was rendered by Magistrate Judge Megan E. Marshall, who became the first jurist in the case, and she presided over the case for a period of several months. And then finally, the 4th incredibly important document was that warrant that Detective Payne asked for. The next day, in the early morning hours of the 30th of December, across the country from Idaho, in eastern Pennsylvania in the Pocono Mountains, Mr. Kohberger was arrested. And he was arrested by the 2 Pennsylvania state troopers who filed an affidavit of probable cause in Pennsylvania. If you have not read Commonwealth of Pennsylvania versus Kohberger, I really encourage you to do that, because it has all of the documents from Pennsylvania. Because this was another state, Idaho couldn't go triumphing into Pennsylvania, break in and arrest him. They had to work with the local authorities. And you'll see the Pennsylvania affidavit of probable cause by Pennsylvania State Trooper Leary. He actually physically arrested Mr. Kohberger and Knoll. And you will see other documents. That case was dormant for a very long time until recently, which we're going to cover in just a moment. Mr. Kohberger made a first appearance in Pennsylvania on the 30th of December. There was then an extradition hearing that was scheduled in early January. He could have fought extradition back to Idaho. He did not. He willingly returned to Idaho. And those documents are also in Idaho, in Commonwealth of Pennsylvania versus Kohberger. He returned on the 4th of January, first appearance that day before Judge Marshall, and that's when you saw him in the orange for the first time in an Idaho courtroom. There were cameras in the courtroom at the time, and Judge Marshall read what the charges were to him. There was an agreement for a preliminary hearing that was scheduled to occur the end of June. It was going to be almost like a mini trial, where there would be a presentation by the prosecution and a defense by the defense to see if Mr. Kohberger should be bound over for trial. There were also several things that happened in January, February, March, in the early months. Number one, day 4 of the case, January 4th, 2023, there was an order, the non-dissemination order, the first of 2 that Judge Marshall would sign in January. The third one that came into effect, it was amended twice, the non-dissemination order, was signed by Judge John Judge in the summer, and that is the non-dissemination order that Judge Hippler is talking about right now with what happened recently, which we'll get to in a few minutes. Also in those early months, there was the process of discovery. Now, when you see a request for discovery, all that means, ladies and gentlemen, is one side is asking the other side to turn over what they believe is evidence that's relevant to their case, state or defense, that they believe the other side has in their custody, possession, or control. And we have seen multiple requests for discovery, motions to compel over time. What's a motion to compel? That's where one side believes the other is withholding discoverable evidence, and they have to have a hearing before the court. Very, very key event that happened in May, specifically May 16th. This was shortly before the preliminary hearing was supposed to happen. And that's when the indictment by the grand jury in Latah County was filed, May 16th, 2023, was filed on the docket. You can read it, and has the 5 counts exactly as they're laid out in the criminal complaint. No one knows why. Count 2 is Madison versus Kaylee versus Xana versus Ethan. There's been all sorts of speculation. That's the way that they're laid out. Hopefully at trial, we're going to find out why it is that that's how the crimes are listed. There was an arraignment a couple of days after the grand jury indictment came down, which is what Mr. Kohberger is standing trial for. He was asked in district court now, got bumped into Judge John Judge's courtroom from Judge Megan E. Marshall when the indictment was filed. And Mr. Kohberger was asked in open court how he pled. If he pled guilty, that would have been it. Then you just go on to sentencing. He did not plead guilty. He did not plead not guilty. There's a lot of misconceptions out there. He said nothing. He did what is called in legal terms, he stood silent. And Ms. Taylor, his lead counsel, who was appointed in December of 2022 to be his lead counsel, advised Judge that Mr. Kohberger was standing silent, meaning basically he wasn't entering a plea. Judge is who entered the pleas of not guilty for the 5 counts. First-degree burglary. Count 2 is Madison, 3 Kaylee, 4 Xana, 5 Ethan. Over the course of the next several months, there was a lot of back and forth with discovery. Big issue in the early days in Latah County 2023 had to do with IgG, DNA evidence, and back and forth with discovery and motions to compel and hearings under seal, declarations, affidavits. And then we move into January of 2024. Big event happened the 30th of January, 2024. And that's when Mr. Kohberger moved for a change of venue on the grounds of too much pretrial publicity. And he felt that it implicated his due process privileges. Now you're going to see, and you have seen, guaranteed if you've read the documents, many times, usually the defense, but sometimes the state will raise it as well. U.S. constitutional amendments. Sometimes it'll be the First Amendment, freedom of speech, the press, religion. That's the 5 freedoms that we see in the First Amendment, basically speech, expression, and the press in a criminal case like this. Fifth and Sixth Amendment have to do with all of the privileges that someone has when they're arrested, remain silent, counsel, double jeopardy. What's that? That was a question that I did get from one of my long-term followers of the podcast. What does double jeopardy mean? Double jeopardy means if there is a trial and it goes to jury and the jury returns a verdict of not guilty, Mr. Kohberger can never be tried for these same 5 crimes again. That's it at the state level. Could he be tried at the federal level for other crimes? Yes, possibility that that could happen. But as far as that's what double jeopardy means. Not if there's a mistrial. If there is a conviction, if there is a return of not guilty, that's what that privilege means. And then we have the 14th Amendment, one of the greatest, I believe personally, that we have, which is the due process clause of the 14th Amendment. You're going to see that come up, and you've seen it come up. You've seen it in the motion for change of venue. Mr. Kohberger's due process privileges are violated. Too much pretrial publicity. All of this evidence somehow got leaked out to the media. Evidence that is prejudicial to him. It's violated his due process privileges. That is found under the 14th Amendment to the United States Constitution, second section of that amendment. And it says, when a government is seeking to take a person's 3 things, either property, liberty, or life, they must be given due process of law, which are 3 other things: notice, opportunity to be heard, and impartiality. That is where all that you've seen in this motion to continue and other motions that have been filed that raises the due process privilege about all of this pretrial publicity, bang, it's the 14th Amendment due process clause. There's a comparable amendment also in the Idaho Constitution, but like all of the states that have their constitutions, they're mirrored after the federal. We fast forward to September of 2024. Judge agreed that venue should be changed. So therefore, what he did, very unusual, is he said, I'm granting this motion. That's what a motion is. It's an application for a court order. It is a request, one party. I can't call up the judge and say, Judge Stephen J. Hitler, I'd like you to grant this motion to continue. Nope, can't do that. Have to do it in the form of a written motion. Granted, motion to continue. But judge, caveat thrown in there, no one was, I wasn't expecting. He did not say which of the 3 venues that the state threw out or the ones that the defense threw out. He said, we're going to leave it up to the Idaho Supreme Court. You decide. Well, the Idaho Supreme Court on the 12th of September comes back with not only saying that it would be change of venue to Ada County, but they personally selected the judge. It wasn't done. Usually when a case is open in a county somewhere, in a district, it's almost like a lottery type thing. You know, which judge, who's down on cases, or who should it go to? Nope. This came directly from an order of the Idaho Supreme Court. Judge Stephen J. Hitler is the jurist, and he cannot be removed unless there is, and they cite the statute, and it's basically if there's a granting of a motion for recusal for some reason or other. So it's been Judge Stephen J. Hitler since September 12th, 2025. We all recall, if you've been following the case, Mr. Kohberger taking that plane from Lake County up to Ada County. They had the first hearing at the end of September, and then comes what I call, for I know that you people, you are document lovers. This is it. This is it. Very well worn. This is the roadmap for the case. Judge Hitler called it the redacted order governing further criminal proceedings and notice of trial setting. I call it the pretrial and trial order. And if you look at this document, you're going to see Voir Dire, July 30th, 2025, 9:00 a.m. What does that mean? That's when a group of people who were selected for possible jury duty will go to Judge Hitler's courtroom, and both sides, and possibly even the court, are going to ask potential jurors questions. And what the goal is to try to find 12 unbiased jurors. Remember, always think about the 14th Amendment due process clause, impartiality. 12, and then what the judge said is he was going to order 8 alternates. That's the maximum he could under Idaho law. So they're going to be looking for 20 people. Before that, if we also look at the roadmap here. Jury questionnaires will be administered approximately redacted 2025. That is the only part of this order that's redacted, when those jury questionnaires are going to go out. They may have gone out already. We don't know. They may be going out after this hearing on the 18th, maybe in July. We don't know. What we do know is what is going to happen with that jury questionnaire. People are going to come down to the courthouse. They're required to fill it out at the courthouse. None of this, sometimes it's just done over the internet business. And it's basically a pre-screening tool to help to determine if this person should continue on. Let's just say the person summoned to the courthouse to fill out the jury questionnaire and they're moving out of state at the time of trial. They need to go. They need to go. Hello to everybody. I want to say hello to Monica. I know she's out there as our moderator. Say hi to everybody, to Monica. Thank you, Monica, for being here today. So the jury questionnaire is going to be disseminated and administered in the courthouse. Date unknown. Judge Hippler has said that both sides can watch, and Mr. Kohberger if he wants to. So this is all what's going on right now. Then after change of venue, we saw all the hearings, and it was tied to this document. If you go to pages 2 and 3, you're going to see a schedule for the DP motions. All of them, the motions to strike the DP, denied thus far by Judge Stephen J. Hippler. Discovery motions, Rule 12 motions to suppress evidence, all denied. Motion for a Franks hearing, denied. And then we have the in limine motions. And I want to refer to a couple of the in limine motions as it relates to alternate perpetrators in just a moment. Then we see, if you read this document, you're going to see the schedule of when the expert disclosures, when the lay witness disclosures were supposed to be, when proposed jury instructions, when questions for the jury questionnaires. It's all in here, down to when you are watching this trial. If you see an exhibit with a blue versus a red sticker, you're going to know red state, blue defense, because Judge Hippler said so in this document, page 3. He has mapped everything out here. We then come forward to the in limine hearings. Remember that really long day of hearings that happened on the 9th of April. One of them had to do with family members in the courtroom. What the state wanted, in limine before trial, motion, application for a court order for a ruling that the family members and the victims could be in the courtroom whether or not they were going to be called to testify. Now, what this means is if someone is going to be getting up on the stand to testify, what'll happen at trial, a lot of times you'll see, I'm invoking the rule, Judge, invoking the rule. That means anyone that's sitting in the courtroom who's going to testify, they get kicked out because they don't want to be having them in there listening to the questions and the answers of witnesses that come before. So what Judge Hippler did, well, what the state did is they wanted an order that and they cited the Constitution, they cited the case law that the family members who were listed in an attachment to that motion could be in the courtroom at all times, soup to nuts, from beginning until end. Nothing stated about Voir Dire. I picked that up. I said, I wonder if part of Voir Dire is going to be closed to the public. That's when my head started to spin. We know how Judge Hippler operates around here, right? I know a lot of you have predicted some of the things that he's ruled on. Well, then what happens is the defense comes back and says, well, Mr. Kohberger has a family as well, and we would like him to be in the them to be in the courtroom. His family loves him. They're not in the courtroom. They attend, which was news to us. They're apparently attending over Zoom. They're watching all proceedings. They can't come to Idaho per defense counsel. It was Eliza Massoth who got up and explained this because of finances. It's not exactly cheap to go from Pennsylvania to Boise, Idaho. And so there was a little bit of a battle. Then it came out, the state said, remember what they said in the response to that motion was, we intend to call members of the Kohberger family at the case in chief. Now, think about what this means. This means the state of Idaho has told us, the public, and the world, that they are going to call certain members of Mr. Kohberger's immediate family, none of the four mentioned, parents and siblings, to be their witness at the case in chief, phase 1, penalty phase, when the state of Idaho has the burden of proving beyond a reasonable doubt evidentiary standard of guilt of all 5 of those felonies. So then Hitler asked the state, okay, you send me something for my eyes only, in camera review. When you see in camera, it doesn't mean they're taking a picture of something. Nope, it means that it's just going to the judge for the judge to see which members of the Kohberger family and for what purpose. And so what the judge came back and said is that whoever you call, they're allowed to be in the courtroom. He's got a right to have his family there. So my mind, and immediately I'm going back to Commonwealth of Pennsylvania versus Kohberger, and I'm looking for any evidence of a domesticated subpoena from Idaho, because Idaho can't go into Monroe County and, knock on the Kohberger family member's door and say, here you go, you're served. You have to go through the process of domestication. And we've seen at least 3 states, Nevada, Washington, and Pennsylvania, where certain witnesses are being subpoenaed, but they have to go through the process of having a court in the local jurisdiction, here Pennsylvania, agree that it is proper to order that Pennsylvania resident to go across the country to Idaho. So what we've seen, remember going back to Commonwealth of Pennsylvania versus Kohberger, that case was dormant from about, I think it was January 3rd, 2023, which is when the extradition paperwork ended. Well, come to find out, in June of 2025, there are subpoenas for trial. And there's a statement from who? Judge Stephen J. Hippler, saying, I am a judge in Idaho. I'm the district court judge. I'm presiding over this case. Based on the affidavit, it was Eliza Masloff, I think, for 4, and then 1 of Ancy Taylor. Of course, it's under seal. We don't know what they said and why, that these witnesses should be. And they put in some language. Some people are thinking that this is alternate perpetrators. It's not. Every subpoena from in a domestication situation will say, I guarantee that if this person comes into this foreign jurisdiction, it's not going to be a trick. They're not going to be served with process. They're not going to be arrested for anything that they did prior to. Now, if they come in and they break the law when they're there, it's a different story. But that does not mean alternate perpetrators. That is a false rumor. That is standard language that you see in these subpoenas. So there's a hearing coming up on the 30th of June to see if the judge in Pennsylvania, he's ordered all 5 of those witnesses to come into his courtroom, same courtroom Mr. Kohberger was in Stroudsburg, Monroe County, where he appeared back the end of 2022, 2023. They got to go to that courthouse. They have to show cause why the judge should not order, the Pennsylvania judge should not order them. And you're like, well, why do they got to go through all this? It's because then there's some teeth. If they don't show up for this trial, then there's a potential to have them held in contempt of court. And that would be a criminal proceeding. So of those 5, none of the Kohberger family members. As of this week, there's nothing for any of the Kohberger family members. Earlier this week, I contacted the press contact. If you look at Commonwealth of Pennsylvania versus Kohberger, you're going to see the name of a woman who's press conference, a contact for Pennsylvania. At first, I called the clerk's office out there and I said, have you received any subpoenas for the domestication of any person by the name of Kohberger? And it was, well, who are you? Put it in writing and send it to this press conference. She contacted me very soon. And she said, basically, anything we've received is on that website. And if we receive something, it's immediately going to go up there. So I just checked it a few minutes ago to see if anything came in on Friday. There is nothing for the Kohberger family. Now, unless they move to another state where nobody has, the local media has found out about these domesticated subpoenas, are they going to serve them? Are they not going to serve them? Have they changed their mind? Are they going to serve them when they enter the courtroom? And then here's your subpoena for trial? Unknown. All we know at this time is nothing is in that file for the Kohberger family members. And so I do recommend, I know you guys love the documents. Keep your eye on that docket. Now let's fast forward to the in limine proceedings. Okay, remember, motion, application for a court order in limine. There were multiple motions in limine. It was the first time that the public, in one of the motions in limine that dealt with suspect vehicle 1 and the admission of evidence regarding suspect vehicle 1, that's the first time the public ever put eyes on an official document from the court of what suspect vehicle 1 looked like. It was in the in limine proceedings. The state and the defense both published them. And so there were rulings on that, the admissibility of other evidence, the 911 call, the text messages, there was another motion in limine regarding Mr. Kohberger's autism diagnosis, alleged autism diagnosis, and other matters. And then state's motion in limine regarding alternate perpetrators evidence. Right here. If you want to take a look at it, it was filed February 21st, 2025. Why February 21st? Because this order, the redacted pretrial and trial order, had set out the deadlines for when in limine motions were to be filed. There was an amendment to it in January. The deadline for filing all of the motions in limine, February 24th. So if you want to see the original motions in limine, all of them, you look at either the filings for the 21st of February or the 24th. That's where they are. This one, extremely important. State was seeking an order in limine preventing the defense from offering evidence of alternate perpetrators at trial unless they satisfied the evidentiary rules in Idaho. They cited to State versus Meister, very important case, seminal case. All parties agree this case is controlling. We've done a few podcast episodes on what that case is, what it means. If you haven't had an opportunity, please listen to that, read the filings before the hearing. Not that we're going to be able to watch the hearing, but it'll give you some background as to what is going on behind the scenes. So what happened next is that the response to this in limine motion right here of the 21st by the state, signed by Alyssa Massoff, had given us the first knowledge of with tens of thousands of tips of suspects during the investigation period, that this case, according to Ms. Massoff, is filled with alternate perpetrators. And Mr. Kohberger was going to be providing offers of proof of not one alternate perpetrator, but alternate perpetrators. Take a look at everything that you see from the defense and everything that the state's filed to in response. Perpetrator is plural. That tells us it's more than one. So then state comes back with its reply. And remember, just a brief overview. Motion, first party is filing the application for the court order. The other side has a due process right to be heard. Response, and then the reply. When that happens, boom, briefings are closed. So what Judge Hippler ordered was that Mr. Kohberger was going to have until a certain date, I think it was May 24th, to submit exhibits and also proof of alternate perpetrators. And how it works is you just can't say, oh, somebody that was standing by the grub truck looks sus to me, looked like he had a weapon in his pocket, was looking at the girls. There was, somebody who was standing outside of the house. There's somebody who drives a similar car. Nope. Can't be conjecture. Can't be theories. Can't be, I think. It's got to be This is the alternate perpetrator. And here is either the direct or the circumstantial evidence that points this person toward being the true perpetrator of the crime, not Mr. Kohberger. That is what is required. So what the defense did is they submitted their offers of proof with the exhibits and the evidence on the 24th of May. State comes back, they file a response in opposition, and then the reply was just filed. So that means the briefings are closed as to alternate perpetrators. Now, I know some people are asking, what? Who are the alternate perpetrators? How strong is this evidence of alternate perpetrators? How weak is it? We don't know, because everything is under seal. The hearing that's going to be happening on the 18th, Wednesday, this week, is under seal. That is oral argument on Mr. Kohberger's motion regarding offers of proof of alternate perpetrators to him. And what this means is that if it's granted, then he would have the opportunity to introduce this evidence to raise reasonable doubt at trial. That is why defendants will offer proof of an alternate perpetrator. There's been a couple of high-profile cases, such as, the OJ case. He said, "Oh, this wasn't OJ. There's an alternate perpetrator. It was a Colombian hit squad because there was a necklace." And all of this other. And they offered that as an alternate perpetrator. Other cases, it wasn't my client. It was someone else. They robbed the house next door. Lacey Peterson case, that was the alternate perpetrator that was offered up there. The jury didn't buy that. Mr. Peterson was convicted. And so we don't know, because it's all under seal. We do know the pleadings are closed, so there's not going to be anything else that either side's going to file. Judge Hippler is probably looking at that right now, if he hasn't already, along with his staff attorney, writing down, questions he's going to ask at oral argument. Now, because we don't know what is going to happen during that hearing, let's focus our attention to the hearing that we know about, and then we'll take some questions. I know that some of you have questions. Hello to everybody in chat. Thank you for being here. Okay, so we have to go back to May 20th of 2025. This was after Judge Stephen J. Hippler had a few words to say at the final pretrial conference regarding the infamous leak to Dateline, where all of this apparent evidence that was under seal, some of it might not even be admissible, somehow made its way to Dateline. And there was a special 2-hour special, May 9th, 2025. Have many of you people watched it? Any part of it in chat? Have you seen that documentary? That was the first time we saw video of we never saw video of suspect vehicle went anywhere. There were documents about what was supposedly on the 8458 phone, photographs, information of these people that had never, supposedly had knowledge, were at this pool party where Mr. Kohberger was. I think it's pretty much, I think people would agree that it wasn't really favorable to him. It was something that, as Ms. Taylor had said, this was inherently unfavorable to him, and it made him look very guilty. And I think that's her strongest argument in the motion to continue. And that's under it's like the page 32, 33. It's the 5th section that she talks about the impact on Mr. Kohberger's due process privileges, all of this pretrial publicity. And then it's not even done. So I'm seeing a lot of people. I refuse to watch propaganda. You've seen it, shaking your head. Yes, I watched the whole thing. So after that happened, that there were the 2 orders that came out on the day of the final pretrial conference. It was the order to hold records, stay basically. I've got it right here in my pile of Judge Hippler orders, the document and records hold order. And what the court said is based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case and the defendant, Bryan Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Now, when he's talking about the non-dissemination order, it's the third version. It's the one that Judge entered in, I think it was June of 2023. It's the third one, not the two that Judge Marshall. It's the third one. That's the operative non-dissemination order. It continues. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impedes the ability to seat an impartial jury. So there we have the due process concern directly from the horse's mouth, directly from Judge Hippler. We haven't heard a word really since then. It's been a month, and there was talk about possibly the court ordering a special investigation, a special prosecutor who would have the ability to enter subpoenas, make findings of fact, and present them to the court to see what should be done. The court is damned. He said this person must be held to account for this violation. There hasn't been a word from the court. What we're able to glean, and this is why it's so important to read the documents, is in the state's response in opposition to the motion to continue, the state said in there, we are committed to finding who did this. So at least from the 5th of June, when that document was filed, that tells us the state doesn't know who violated. And why this is a concern, at least for me, and I'm going to give my opinion as I do under the Fifth Amendment, under the First Amendment of the United States Constitution, is what we've got Judge Hippler saying he believes it's a member of law enforcement or the prosecution's team. What if it's a member of law enforcement who's on the state's witness list? And then that person is on the stand and the defense doesn't know that this was the person who leaked this evidence. We think that might possibly be grounds for a reversal. That's my concern about this. Now, what the state said in their response of the 5th, they made a lot of good points. They said that a lot of the things that Ms. Taylor is saying here, that there wasn't enough time, that they have to sift through discovery. The judge has already commented, ruled on it. You know, if you needed more time, if you needed more paralegals, why didn't you ask for it? The state said, you know, this order of the 9th of October has been out for multiple months, and they're waiting until the 20th of May to now look to continue the trial. And then they raised the very important point that the Idaho Constitution also guarantees the victims the right to a timely trial. And it's going to be almost 3 years that this crime happened in November. So there's a lot of things that Hippler has to kind of weigh here with this motion to continue. Let's talk about this motion to continue a little bit more. May 20th, 2025. Fortunately, it is not sealed. 40 pages. It's there for you to read. And I do recommend, if you're going to watch the hearing on Wednesday, which I hope you do, that you read the motion to continue. It's signed by Ann Taylor. She gives you a very helpful, I think, grid. And I've actually used this myself when I had to file something recently, where it's a little overview for the court, pages 2 and 3. And she writes where, for example, argument 1, the court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time. Mr. Kohberger has a myriad constitutional rights during this proceedings, all of which are dependent on counsel having the time and resources to prepare. And then it goes on to the fact that this is a capital case, that a lot of capital, they get reversed. The single most important argument, as I've said, I circled it. When I saw this thing, I circled it in green, paragraph 5. It starts on page number 32, and it addresses the fact that we've had this, and this is not the end of it. From what we understand, there is a book that she talked about that's coming out from a a top true crime writer, James Patterson, that's coming out mid-July. Why mid-July? Marketing people are not dumb. They know that that's where there's going to be maximum eyes on this case because of Voir Dire coming up, unless there's a continuance. Voir Dire is happening on the 30th of July. So they're going to go ahead and publish this book before there's a trial on that date. Mr. Patterson says that there are interviews with something like 300 people. At least that's what the marketing for this book says. Some, people that haven't spoken before and have inside information. Is there a possible second leak because of that? And then that there's a docuseries 4-part also coming out mid part of July. I watched the trailer for it, and there's a person there who says that she was in the house along with the other people that were in the house right before 911 was called that we've never heard of before as the public. There's interviews with 2 of the people that you hear on the 911 call. There's interviews with the 2 surviving triplets to Ethan. We've never heard from these people before. And so now the question is, what is Judge Hippler going to do about it? What the defense is facing now in the response is what Mr. Thompson said, is there are a lot of procedures in place. It's not the amount of pretrial publicity. It is, can we seat 20 people? They need 20 people who can be impartial. That's what satisfies due process. So we have the motion that was filed on the 20th of May. That is what this hearing is on. It's oral argument on the motion to continue. Not to delay, not to move, all these terms. The term is to continue. It's usually to continue a hearing or a trial. This is to continue the trial date that's set forth in the October 9th, 2024 pretrial and trial order. The response came the 5th of June, and I got to say, state raised a good argument about, also constitutional rights of the victims, that some of these arguments before this court is already sort of, disposed of. We can get past, nobody's going to get seated who can't be impartial and fair. Please don't move the trial date. That's what the response says. We're waiting for a reply. Remember, pleadings, motion, response, reply. Reply from the defense responding to the response. So I'm anticipating it hasn't hit the case summary page or docket, at least as of Friday the 13th, which was the last time it was updated. I'm going to look for it Monday, Tuesday. If they do, I will let you know that the reply has been filed. And what I would be shocked if Ms. Taylor does not raise the issue that last year, when there were remember all the studies that happened for those of you that have been following the case for a while, there were a bunch of expert witnesses who got on the stand on, I think it was the August 30th hearing on the motion to change venue, who talked about the impact of negative pretrial publicity and how it impacted people in Latah County who responded to the surveys that they were asking. And in that survey, there was a large number of people in Ada County who felt Mr. Kohberger was guilty already. And we're talking a year ago. And now with all of this press, if she doesn't bring that up, I would be very shocked. As a matter of fact, I'm surprised they didn't hire an expert witness to try to do something and address what happened with this Dateline episode, and now this Patterson book, and now this docuseries. So we're going to wait for the reply. Hearing 12:30 p.m. 12:30 is when it starts, and it's starting with the open hearing. What can we expect to see then? Well, once it goes live on the Ada County, the official channel, you're going to see Judge Hippler do what he does every hearing. He's going to say a few words, and then because this is the defense's motion, the first person who's going to get up is going to be somebody from the defense side of the courtroom. It's probably going to be Ann Taylor because she filed the motion to continue, and she's going to get up. This is not a time for her to go over her 40-page memorandum. Hippler has seen it. He understands it, guaranteed. He's read it. Probably his attorney, staff attorney has read it. They've probably done some research on their own. She should get up there and give maybe 2 of her 3 strongest points. That's it. And then answer whatever questions Hitler may have of her. And be prepared, anticipate what he's going to ask. And then when she's done, when she's done speaking, attention's going to turn over to the state side. And it's probably going to be Mr. Thompson, because he filed the response in opposition to the motion to continue, who will then get up. Ideally, he's going to give 2 or 3 of his strongest points. He will answer whatever questions Judge Hitler asks of him, and then he will sit down, and then Taylor will probably get up again and give a final few more rebuttal to the response. Hitler may ask a few questions. It goes, an oral argument, it follows exactly how the briefings go. Motion, defense speaks first, response, then the state, reply, defense, sits down. Hitler, I'm waiting to see if he gives us any kernels of information as to how he's leaning at this hearing. He may rule from the bench. He did it at the in limine. On some of the motions in limine, he ruled from the bench. He said, granted, reserve ruling, denied, on whosever motion it was. And then there was a long order. It was like 20 pages that came out on the 18th of April that memorialized the verbal. It's called a proclamation from the bench. He ruled from the bench, but he's got to put it in writing. He's got to put it in writing. Or he may say, I'll take it under advisement. Okay, now we're going to move into closed session. What does take it under advisement mean? He's going to take what the state has said, what the defense has said, and then he's going to think about it. He's probably going to do his own research, and then we're going to wait for the order to come. So there's a possibility that the ruling is going to come at hearing. And if that happens, if it is granted, that's it. The trial date gets continued. This motion or this court order of the 9th of October, the pretrial and trial order, gets amended with a new trial date, new voir dire, new questionnaires, and all of that. If Hitler denies that motion to continue, then everything proceeds according to the October 9th, 2024 pretrial and trial order, page 1, item number 2, voir dire the 30th of July, item number 3, August 11th. Case in chief starts. That is phase 1. It's called the guilt phase. It's when the state has to prove its case beyond a reasonable doubt. Beyond a reasonable doubt of what? Evidence. Evidentiary standard. Not of the stuff that we've seen outside, but whatever evidence is admitted into the case before the jury. The burden of proof is beyond a reasonable doubt for count 1, burglary, and then the 2, 3, 4, and 5. Those are the counts to which the DP attaches, not count 1. I think it's 10 years imprisonment and restitution and some other things, maximum for count 1. It's 2 through 5 that attach with it the capital punishment potential DP. At the end of the trial, jury goes into the jury room. They go over everything. Hopefully they come up with the correct verdict, whatever it is. And then they come out, they announce their verdict. Again, if it's not guilty, Mr. Kohberger cannot be tried again. The double jeopardy provision of the Constitution attaches, and that's it. If it's guilty, then it sounds like it's going to immediately go into the sentencing phase, which is when the issue of what is the appropriate sentence for this crime. Is it capital? Is it something less? If you've been looking at the docket and you've been following our filings, and we're up to 715 episodes of the Indie Zone podcast, 5 minutes or less, we go over every single filing on the docket. There has been a tremendous amount of information that the defense has filed for mitigation purposes in the event of a conviction. The state also gave us some kernels of information. You can read it in their response. they tell us how many thousands of pages and how many witnesses for the penalty phase. If there's a conviction, they're going to go immediately into the penalty phase, and then you start seeing the witnesses for both sides. The state has said they're going to seek the DP, the witnesses coming in, why it should be the DP. Defense is going to bring on their case, why it should be something less to mitigate, and then the jury then goes back and makes a second ruling, and then when that's announced, the case is truly over, barring any appeals, which we can pretty much guarantee that there's going to be appeals in this case in the event of a conviction. Possibly even if there's a not guilty, there may be some type of an appeal from the state side. So we're waiting for this hearing on the 18th. We're going to hopefully get some kernels of information. He might even throw out a few things. You can watch his body language, words he says, that might give us some hints as to how he's leaning regarding the offers of proof of alternate perpetrators at that hearing. So this is, I've said this for all of the hearings thus far. I said the motions to suppress, the most important hearing of the case. Motion to eliminate, most important hearing. This is truly a game changer, because if he is granted the right to bring in these alternate perpetrators, that will be a big win for Mr. Kohberger. If he's denied, it will be a big win for the state. If the trials continue, it doesn't mean the charges go away, but it gives the defense a few more months or however long. That was one thing the state said. You didn't even give a time frame. You know, what are we talking about here? We're talking about a couple of months. We're talking about a year. You didn't even give a time frame. So we're going to have to wait and see. After those hearings, we should be getting rulings on paper as to granted or denied the two defense motions. So with that said, are there any questions? I've been speaking and talking, and okay, beyond a reasonable doubt is the highest standard of proof. Snoopy Red, glad to have you with us today, Snoopy. Beyond a reasonable doubt is the highest standard of proof required in criminal trials. Evidence presented must be so convincing that no reasonable person would question the defendant's guilt. That's a good way of putting what reasonable doubt is. Let's hope that this jury makes the right decision based on the evidence that's presented. Gee whiz, hey, glad to see you. Do you think if continued is denied, that it will be after the DP is removed? Well, right now, there are no further motions to strike the DP that we're aware of. There's been a lot of stuff that's been happening under seal of late, including there's some type of motion that the defense has filed for some type of an investigation. And some people are guessing that it's about this special prosecutor. We don't know. There is no motion on the table, at least that's on the public docket, to strike the DP. Now, could Ann Taylor ask as a remedy, if it comes back, that it was in fact someone from the state side who intentionally violated that non-dissemination order? That's contempt of court, ladies and gentlemen. If it's anyone who was under that umbrella of that non-dissemination order, who went ahead anyway and defied Judge Hippler, who has people have come, they've tried to get documents and they're told, no, you got to file a request with, a regular request, a public records request. There was a request that was done just a couple of days before the State Line episode came out, where Hippler said, nope, you got to go through. You're not getting documents that are under seal this way. So there is no motion to strike the DP, but I'm glad you asked that question, because there's been some references, right? The state of Idaho versus Lori Noreen Vallow, aka Lori Noreen Vallow Daybell, right? We even see Judge Hippler himself, who was interviewed a couple of years ago. He's the administrative judge for the entire 4th District. So he's in there managing courtroom processes, policies, and procedures, making sure things happen. And he at that time was talking about they were able to manage the Daybell case. Well, just before Lori Noreen Vallow was about to go on trial in a DP case, the defense filed a motion for sanctions because the state missed a deadline to get discovery to them. And they were looking to have the DP stricken as a sanction. And guess what? It's exactly what happened. Stephen W. Boyce, the district judge, in case number CR 22-21-1624. This was filed on March 21st, 2023. For the reasons stated on the record from the bench, remember that's a proclamation from the bench, an oral ruling. He's memorializing it to writing. For the reasons stated on the record from the bench in a hearing on March 21st, 2023, that same day, the defendant's motion to dismiss the DP filed March 5th is granted. It was granted as a sanction because I think it was one day they missed a deadline. They missed a court-ordered deadline. The state's notice of intent to seek DP filed May 2nd, 2022. Bam, stricken from the record. So let's see what happens. Any other questions, Kathy? I'm so glad. I'm so happy that you made it here for a live Snoopy. Thank you. Bryan, I hope they have a path to justice. Can Judge Hippler go ahead with the trial date and then delay the sentencing phase if BK is found? I guess he could possibly do that. That's a great question because thank you, Layla, for asking that. We go back to the October 9th, 2024 pretrial and trial order, blueprint for the case. Please read that order. Such important information it will give you. Judge Hippler said, trial starts 11th of August. It runs through November 7th, inclusive of penalty phase. And then Judge Hippler throws in the words, if necessary. Clue to us, ladies and gentlemen, that he's saying if there's a not guilty verdict, then there is no sentencing phase. It could possibly be he might put in, okay, well, we'll go ahead with the case in chief, but the sentencing phase will move. But then the problem becomes then it's got to be the same jurors. So what do? Do they get to go home and then come back? Could they be exposed? So we're going to have to wait and see. But that's a really good question regarding if he could just delay, continue the sentencing. I think it would create some problems for the jurors. He's already talking about sequestering these jurors. He's already talking about having to sequester them because of this quote unquote leak, aka possible violation of the non-dissemination order. Okay, Teresa, it's them, blah, blah, blah. Any other questions? Thank you. I'm glad that you made it here today. I'm hoping Ann has something very strong that will change the trajectory of the trial, something solid. Yeah, crime spy, as I said, I would be very, very surprised if she doesn't include, look at some of the findings from 2024 from remember Dr. Edelman with his infamous PowerPoint presentations? He's the one that did the survey. And he found that it was a lot of people in Ada County that as of the time that he took the survey, that they surveyed on the phone, felt that Mr. Kohberger was guilty. And now it's a year later, but then the issue becomes, if this case is of such unique high profile that, let's just say it gets adjourned 3 more months, then what if there's more leaks and more problems? I'm sure all of this is going through Hippler's head right now. We're going to have to wait and see what happens with respect to this. Hopefully we get something as the public as to what is the status of what the state and the defense both submitted in camera under seal to Judge Hippler in response to that order, directing them to give the names of everybody who either currently or in the past had access to this information, told the state, what are you going to do to prevent any further leaks from happening in future? Telling everybody they are not to, what's called, go in there and try and erase things. Make sure that you deliver this order to everybody who's ever had access to this information. He's really serious about this. So I'm sure there are things going on behind the scene. I just wish that he would have let us know a little bit of what's going on. Okay, you're welcome. Thanks for answering. Of course, I'm hoping Ann has something. I think Ann has the goods. Tree says feeling. Sorry, I meant to say Hippler, Judge Hippler. Any other questions that we have out there? Very important question. Prime is already putting out commercials. Open Mind Perspective is reporting that Prime is Prime who is, hi Jeff, how are you? Is Prime who is putting out this docuseries. Okay, they're saying that they're all ready. We're going to have to wait and see. The other thing that has been asked, I wrote it down here. My gosh, my memory, if I don't remember. What about any of the other pretrial motions, such as alibi defense? Well, I went on the record in Latah County. I think it's like episode 70 of the Indie Zone podcast, questioning this partial alibi defense that the state spent a lot of time on, knowing what the statute said. The statute says you can't have a partial alibi. You have to have a full alibi. You need to have corroborating evidence. Remember, that's when the state of Idaho came forward. That was one of the limine motions and said there's no such thing as a partial alibi. 100% correct. Also said that, he's had a year and a half. You're supposed to present this proof within X number of days. This is part of the statute. Hippler had no authority to change what a statute says. The statute's clear and ambiguous. You can't change statute. And that statute is the same in all 50 states, and it's also federal. You need to be able to have corroborating evidence of an alternative alibi defense. What's that mean? That comes up a lot, where defendants will say, got the wrong person. I was in Europe, and here I am by the Eiffel Tower, and here's my whatever, my colleague. We were on some type of an excursion for work, and my colleague is going to come in and will testify as to where. A lot of times it's work related. The manager will come in and say, yeah, John or Jean or Jamal or Cindy or Brittany was working, and here's the video from inside the warehouse. And, I spoke with her personally, or him. That's an alibi defense. He offered a partial alibi, and Judge Hippler said, I'm sorry, I have no discretion. And that was the correct ruling. He got it right that time. I think he got a lot of the rulings right. Even on the suppression motion, there were standing that was missed and some other things. But that one, I don't like that he's hiding a lot. I say hiding, but things are under seal. But the alibi defense got thrown out. Nope, denied. You have to have a full alibi. And there has not been anything that we're aware of. I haven't seen anything on the case summary page. There's nothing that has been put on the docket regarding an alibi. And what Mr. Kohberger was said, reasonable time before trial. So the ruling came out in April. We're now, middle of June, nothing regarding an alibi defense. Maybe it'll be filing one in the coming days. We'll keep monitoring the docket to see if it gets answered. Okay. Hey, Christy, good to see you. What if Bryan has pictures of the sky lighting up on his phone at 4:36? It would be time-stamped if the state didn't delete the picture. Oh, that's true. Well, we'll see. Hopefully we're going to see a trial. Admissible evidence from the infamous 8458 phone. Here's something that I sort of threw out. The affidavit of probable cause in Pennsylvania had an attachment, Exhibit A, from Detective Payne, who had some instructions in there about how they could possibly, once they secured the 8458 phone, how they could through other ways possible. They were really interested in getting in that phone. Possible, not accusing anybody, but is it possible that this leak happened from someone out of state that's not under we don't know. Everything is under seal. We're going to have to wait and see. I don't know how much I'm allowed to say. After all, they didn't witness. That's true. Okay, Snoopy. I have never heard a judge order state and defense come up with a story as to how someone became a suspect. Blah, 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 Snoopy. Any other questions? Must be an Idaho thing to have to provide it. No. Bad mom. Please, if I've misstated anything. There is no requirement. There is no requirement. No defendant is required to have to raise an alibi. They do it willingly. They do it in order to, it's a defense to the charges. And sometimes it's a very good defense if they can come up with competent proof that you got the wrong person. And here's my doctor saying I was in the hospital, with a broken leg. I didn't do it. And here comes Dr. Smith, who's going to get on that stand and say, yeah, here's the video from the hospital. I treated him. That's an alibi defense. Okay, any other, did the special prosecutor? We don't know, Susan. That's the question of the hour that I would like. This is one thing I don't like that is continuing to go on. We've had this leak of all this information that we now know appears to be from the sealed records, but yet we're told we the public can't even know what's going on with this special prosecutor if there is an investigation. There's a lot of things that were filed under seal in the past week, and I've been really frustrated about it because Judge Stephen J. Hippler very clearly said, in order to get something under seal, you must not only cite legal authority, but you have to say why it is that this needs to be sealed. And there was a couple of things that slipped by that just cited to the law with not good cause, and he signed orders sealing it. So hopefully, I'm really thinking that we're going to get some good information Wednesday. So please watch, if you can. Please watch the hearings live. Okay, any other questions? Dinky. Hi, Dinky is here. I have a question. Shouldn't Hippler at most have been removed, at least been investigated for calling side? Well, Lanai Kai, in order to remove Judge Hippler, what needed to happen, and this comes directly from the Idaho Supreme Court, is that he could only be removed by statute. There needed to be a motion to recuse him from the defense. Defense basically coming in and saying, we want you kicked off, Judge Hippler. You need to get out of this case. They didn't file anything. The defense has not filed a motion to recuse. It would be, I think, contingent upon them to file a motion to get him kicked off the case if they found they had legal grounds to do so. So until or unless they do that, and there's an order kicking him off the case and assigning it to another judge or another venue. Another thing is, could there be, people have asked on the podcast, I'm glad you asked that question because I totally forgot it. Now I can cross it off. Could venue be changed again? Well, there needs to be a motion to change venue. And as far as we know, there is no motion to change venue that is pending in the case. That should have been something that would have been on the case summary page, one of the 99 pages of late, or on the docket, motion for change of venue. Nothing. The only motion for change of venue that has been ever filed in the case, January 30th, 2024, to get the case out of Latah County. There has been nothing since. Any other questions? Delphi is the most egregious miscarriage, apart from, I've seen so much trying to, down the rabbit hole. Yeah, I think I've never, first off, I think more things than should have been under seal have been put under seal. I'm saying this from looking at every single document on that docket, as I've had to do for the podcast. All the podcast, 5 minutes or less. If you want to get caught up on the case, it's on Spotify, it's on Amazon, it's on Listen Notes, it's on a few other Amazon. It's on some places I've never even heard of, but it's on the YouTube channel. And I like the YouTube channel because it's got a search engine. That docket is unsearchable. It's in 2 parts. And sometimes the titles of the documents don't tell you what they really are. So if you're interested in change of venue or motion to recuse or indictment or prejudice, things like that, if you put those terms in, it'll pull up the episodes for you. Or if you want to start from episode 1, which is affidavit of probable cause, page 1, just go to where it says videos and flip on oldest, and it's going to start from episode 1 through 18, which is the 18 pages of the PCA on through to the last episode, which was on an order that was rendered. I think it was on the 12th of June. That's what we're up to right now. Okay. Anything on the rest of the DoorDash driver legit? What arrest of the DoorDash driver? I didn't recall. Somebody's asking a question about the DoorDash. First off, quite a bit of secrecy in the affidavit of probable cause. I noted that immediately when I got to that page of the PCA on the podcast. Detective Payne gave us the name of Kaylee's ex-boyfriend, full name in the PCA. There are initials for the surviving roommates. The name of the medical examiner is redacted. The private driver name is redacted in Idaho, but it is unredacted in Commonwealth of Pennsylvania versus Kohberger affidavit of probable cause. So we have the name, gives you at least his gender in Idaho. Nothing about the DoorDash driver. And I have wondered, and I just wonder, is this just, whatever? Detective Payne just, forgot to use initials or didn't give us, we don't even know if it's a male or a female in the official documents. So I'm curious about this information regarding an arrest. There's a camcorder video of her arrest. But how do we know her name if it's not in the documents? We don't know. She's probably on the witness list for sure. I think pretty much guaranteed she's on the witness list, but the witness lists are under seal. And all of the evidence that came back from DoorDash, there's nothing. We have nothing in the official records. And I go by the official records. I know that sometimes we'll go out, we'll do research, we'll find things, but if it's not in the official records, I'm always a bit concerned. Okay, so there's some video that's going around, and initials are MM in the documents for e.g. the private driver are her initials. So the initials given of MM. Can Hitler stop the book from coming out? Can Hitler stop the book from coming out? I think that would be really difficult. You're going up against the First Amendment. I don't think there's enough time to do it. It'd have to be an emergency thing. And it's almost like a lot of the cat's been out of the bag already. So I think it would be hard. I think it'd be really hard to put a stop to that book from coming out. I think it's going to come out mid-July along with this docuseries. Okay, state star witness Dinky saying she is this. Who's the state star witness, Dinky? Her name is Kathy. I watched the video on the DoorDash driver. She was arrested for. Okay, so we're looking forward. Okay, so there's some information out there, not on the public record about this. So I'm interested. Translucent has the whole video of the arrest. Okay, this is called the DoorDash driver. Molly. Okay. All right, so we have all of that. I've also reported, just as another thing, we know about the Idaho 4 defamation case. It's sort of running in parallel with this case. The Idaho 4 defamation case was filed in federal court, in district court in Idaho, under what's called diversity of citizenship. Usually when there's a defamation case, it's a local case. If you're a resident of Idaho and you feel somebody else has defamed you, you would file the lawsuit in state court. That's typically what's called a tort, defamation of someone, written defamation, libel, spoken word, that's slander. There was a lawsuit that was filed in federal court. I think it was around the 22nd of December. It was before Mr. Kohberger's arrest, of a professor of the University of Idaho who filed, and she, believe it or not, she's being represented by the same attorney who represented the Media Coalition in this case. Same attorney, same law firm. So apparently what the documents say is that this, she was called a TikTok, YouTube sleuth, psychic who gave the name of the professor, said that she had alleged, well, she's granted summary judgment, so the court has found that this happened, partial summary judgment liability. The court found that their defamation had happened, that she was defamed. There was no, a truth is an affirmative defense to defamation. If it's true, you can't be defamed. That's just bottom line. You're going to be knocked out of case. So in her defenses, the defendant was unable to give any proper defenses that convinced the court that there was grounds for her to say what she did. So it was called partial summary judgment as to liability. They've been wanting a trial. The Idaho District Court, it's under diversity of citizenship. You can file some of these lawsuits sometime in federal court. If you're a citizen of one state, the other party's a citizen of another state. Hear what the Professor Schofield, she's an art history professor, U of I, did is filed the lawsuit in district court in Idaho, and I believe it's in Boise, is where the courthouse, the district court is. And so what the judge did is she went back and she filed a motion for reconsideration. She had said she tried to get documents in this case. That's the situation that I was just talking about a couple days before, all heck came out with the Dateline case. It was the defendant in the federal case who came to Hitler. She filed a motion. She was asking for documents from this case. Hitler said, no, number one, I'm striking your motion because you're not a party. The only parties, people of the state of Idaho and Mr. Kohberger. That's it. No one else can file anything unless you're an intervener and you're granted that status. So what she did is she filed the public records request, and it's all in the federal court docket. You can read what she asked for. Judge Hitler's order is there. She filed a motion for reconsideration on liability. Judge came back and said no by the 15th of June this month. The two of you, both sides, have got to get together and give a trial date, and this is for damages. So liability has been decided in favor of Professor Schofield. It's now a matter of damages, how much and what the damages are going to be. So these two trials may be happening at the same time, one in federal court and one in state court in Boise. Okay, the DoorDash. Any other questions? The making of reasonable doubt, less legit. Yeah, reasonable doubt, that's it. Keep seeing the name. Kohberger case is finished. It's been stayed until, okay, DoorDash, blah, blah, blah. Any other questions that anyone has? She was parked. Okay, a lot of good comments that everyone has. I'm glad that everyone is real respectful. I think that this channel is unique in that we have a lot of people that, although Mr. Kohberger, under our Constitution, unquestionably, he is considered innocent until or unless this jury convicts him, if they do, or he pleads guilty. That I've got a lot of people from both sides. I'm so appreciative of the people that follow this page. Number one, you're document fiends. You read the documents. You don't have anyone tell you what they say. I appreciate that so much. And I appreciate all the love and the support. And I appreciate that you treat each other. I've got people 100% feel that Mr. Kohberger is guilty. I have people that feel he was set up, and everything in between. And people, when they debate on the records, I appreciate it. Oh, Miller Time. Oh my God. Thank you. Thank you for your kind attention. Thank you for becoming a member of the channel, Miller Time. I really appreciate it. Thank you for spending your Sunday afternoon with us and sharing your thoughts, logic, and knowledge. Thank you, Miller Time. You were fair and neutral, Kathy. That's why I love you too, True Crime. Thank you so much for being here this afternoon. I really appreciate your oh yes, whiteboard. That's what we're all about. When I started this I've been a podcaster for a number of years, independent. I did music, books. I love anything independent, and so I had a podcast. It was dormant for a couple of years. I decided at the end of 2023 to revitalize it, make it a true crime podcast, because I'm very interested in true crime. I'm interested in the investigation. I'm interested in the documents. I'm interested in the facts, all of that. And I knew the Kohberger case was going to be one. And the reason why episodes 1 through 18 is I broke down the affidavit of probable cause, and then I was going to do a couple of others. But then I looked at this case and I said, we got a ton of First Amendment issues. We have a lot of things that are behind, a lot of it, both sides. You could read things both ways. And that's when I decided to exclusively focus on this case. And once this trial is done, then I'm going to open. I know a couple of people had asked, I'm going to do other true crime, always focusing on the documents, because I believe that the people who follow this page, and I have a lot of other content creators who do, and I'm so appreciative and thankful that they do, is that we focus on the documents and we let the documents take us to where, because guess what? The people who follow my page, I don't have a lot of judges and I don't have a lot of attorneys. It's everyday people who will be serving, people that will be serving on the jury, people that are truck drivers, people that are musicians, people that work in retail, people that, hardest job in the world, parents. Happy Father's Day again to everyone. And you are the people that will look probably a lot like the people on the jury. And I feel that everyone and anyone is capable of reading those documents and coming up with your own conclusion. That's what makes this country great. That is how this system of our government was set up by the framers of the Constitution, and then the 13 original colonies who said, we're not signing that unless you give us the Bill of Rights. We got to thank them for the protections that we have. Very important First Amendment, 6th and 14th Amendment. Thank you to the original 13 colonies, even though it was added later. But I feel that the people who follow this podcast and this channel can read and do read the documents. So the podcast is set up very, very brief, 5 minutes or less, tell you where to go on the document, talk you through some of the legalese. I've taught for many years, and before, retired attorney, taught. What I love doing is teaching. That is my absolute, what I'm born to do. I've taught regular people, and I feel that you can read the documents. There's nothing to be, if you have to have a little dictionary out, read in limine, what this means, motion, it's not, that's all it is. It's because you can't call up Judge Hippler and say, Judge Hippler, continue this trial. You got to go through the formal process. So we'll teach about procedure. We're going to be going live at trial. There is no doubt we're going to go through live at trial. That'll be the first time that I'm ever going to be live. First day, no doubt about it. We're going to go live and we are going to walk you through what's going on that day. Sort of like almost as where, and Judge Stephen J. Hippler is also an administrative judge for the 4th Judicial District, and he was appointed by the floor. So we're going to have a lot of that with conversations going. Oh my gosh, thank you so much. Too much to handle. Appreciate you. And oh my gosh, Jackie, much thank you. Thank you, everyone. Michael, it's what I love to do. Thank you. I love teaching. It's what I feel that I was born to do most. And I love all of my students face to face, over the internet, colleagues. Please keep following this case. I think this case is extremely important. It's going to set the precedent, I think, for a lot of cases, how certain things are handled. First Amendment, 5th and 14th Amendment, due process, the press, all of these things. And we're seeing how exciting we're seeing it live. I mean, I hate to say that on the other term, because we have to always be reminded of we're here in search of the truth for Maddie and Kaylee and Xana and Ethan. That's why this podcast exists. That's why this YouTube channel exists. And I know that's why a lot of you are following this case. So thank you, legendary CEO. I appreciate you. Your Constitution and rights under it are beautiful. It's a shame how many Americans ignore. Dinky, well, you know who our common law comes from. They say the common law of the, they talk about common law, something like defamation of character. It comes to, we adopted everything from the British system. So yeah, it's true. I think a lot of people, I think this is a good learning case for a lot of people. Oh my gosh. Animals, thank you. Thank you for being here today. It's true. I want to read again. Dinky has said, that means the United States Constitution and the United States rights are beautiful. It's a shame how many Americans ignore it. So hopefully, hey, Jeff, the website confirms the time, subject matter. Jeff, hey, by the way, I loved I watched your guitar playing the other day. I hope you're going to be doing more of that. I think you're really great at that. And then been following daily with many different podcasters. Susan, I'm going to ask you, okay, how many people, who thinks this trial is going to get continued? Who thinks, and what it is it's going to be, we're going to find out either if Hitler does issue a proclamation from the bench on Wednesday. He may say, and listen for these words, motion to continue. Granted, that means the trial is not going to happen on the 11th. Denied. That means the trial is going to happen on the 11th. So I'd like to know who thinks, just, your gut from what you've read, because I know a lot of people, you are document junkies. You've been reading the documents. You've been studying the case. I hope not for familiar. I don't think so. Okay, so are we saying I don't think so? That it won't be? I think it will be continued. Michael, I think it will be. Michael, what is your opinion on the strongest argument in favor of? Do you think it's because oh my gosh, Miss Macy, thank you. You're so I appreciate you. Thank you for your kindness. Michael, what do you think? Because you feel it will be continued. What do you think is the strongest argument? Hi, Amy Conway. Thank you for being here. Betty Joe, thank you. Can Judge Hitler stop? Okay, I think we talked about it. He can't. Extremely circumstantial evidence. Well, I know a lot of people are saying that everything's circumstantial, but a lot of convictions have happened on circumstantial evidence. And for the other side, in the defense's favor also, offers of proof, alternate perpetrators. Mr. Kohberger doesn't have to show direct evidence. He can show circumstantial evidence. And what about this under seal business that he wants pieces of evidence evaluated independently? Under seal again. Circumstantial evidence, let's not think that it's not as good as direct. In some cases, a lot of criminal attorneys say sometimes circumstantial evidence is as good as, it can be even better than. Down the rabbit hole. Thank you. Appreciate your understanding and knowledge. You have a million. Thank you. Thank you. I appreciate down the rabbit hole. I appreciate your support, your being here, and your feedback. Please, everyone, if you haven't already, I would so appreciate it if you could subscribe to the channel. And here's why. Things are happening fast and furious right now in this case. It's coming at us from left and right and up and down. And we as the public are trying to figure out things. We can get kernels. If there's kernels of information that we can extract out of some of the papers, like we found in the response in opposition to the motion to continue, that the state still doesn't know as of the 5th who violated. We're going to tell you if there's something for you to look at that gives us some information that's under seal in the public record. We're going to point that out for you immediately. Things are coming fast and furious. This trial, if it's not continued, is going to be here before we know it. These jury questionnaires are going to be going out, if they haven't already gone out, very soon. And then Voir Dire, if this trial is not continued, will start in about 5 weeks from now. And there's still a lot that still needs to be resolved. If you subscribe to the channel, you're going to get an automatic notification, a reminder when we do publish new content. So please, if you haven't, I greatly appreciate it. And then if you could like the content, that really helps get our word out there into I guess it's the stratosphere or something. Cheryl, I'm so glad you're here. Cheryl has been thank you, Cheryl. Cheryl has been a supporter from day one. I think you may have come over here from the podcast. I don't know, but I want to thank you for your a lot of times, because I'm DIY. I make the scripts for the podcast. I then go on and I publish and I edit and I put it up. It's all DIY. And then sometimes you're like, why is anybody even listening to this? But it's people like Cheryl who have been with me, I think, since day one, that make me realize that there are people who are listening to this content. And hopefully, as we've curated this content, because it's basically curated, it is on Amazon, for example, to listen to as a listen book, to the case. You can also do it here on, so it's there permanently. You know, if 5 years from now, if somebody hears about this case who maybe was too young and then they're in, you know, in high school or college and they want to listen to how did this case transpire from affidavit probable cause through whatever the verdict is, that podcast is there. And sometimes, you know, when you're not getting feedback, it's like, oh God, maybe I should go do something else with my time. But it's people like Cheryl and Miller Time and have been with me a long time. And the newer people, I really appreciate Down the Rabbit Hole and everyone else. Thank you, Miss Macy. Down the Rabbit Hole it's got great content as well. Sarah, I'm so glad you're here. And she's given me, Sarah is another document. She loves the document. She is constantly looking at that document and she shares information when it's published. Sarah, I'm glad that you're here today. Thank you, Wanda. Thank you. I'm glad that you've liked the channel. The video was just released. DoorDash. Okay, I'm going to have to keep my eyes peeled, I guess, about this content, even though I'm pretty stubborn. I got a really hard head when it comes to I got to focus on the documents. Now you've got me interested in what this content is about DD. So thank you. Well, thank you, everyone. Yvonne, thank you for being, you've been a long-term member, Yvonne. I can't thank you enough. Thanks for being here today. Okay, everyone, are any other questions? Remember, hearing. What Hitler used to do, he slid a little bit, and we're going to have to, I guess, make him slide because we know he's got a lot on his table. But what he did right after change of venue is a few days before, a day before, he would put out an order saying the hearing is going to be live on the YouTube channel. Here's the link. And this is what we're going to look at. We're going to do this DP motion first, and then second, and then third. And this is how much time it's allocated for each side. And if we have to, we'll go into the next day. He did that also with the suppression motions. And when Frank's motion, when it was sort of discussed a little bit, but he didn't do it for the in limine. So it was not until the day of that we knew that the in limine were going to be live streamed. So I'm going to see if he publishes anything about confirming live stream. But because the in limine were live streamed and because he's doing the one under seal, I think he's going to live stream Wednesday. So please go on to Idaho cases of judicial interest, plug that term into any search engine of your choice, like Google or whatever it is. I can't post the links here, external links. That's why I have to tell you where to go to find it. But it will pull up the Idaho cases of high interest. Kohberger is there. It's the only trial case right now that's there. It gives you the two pieces. It gives you the part from Latah County. It gives you the part from Ada County. And then there's a link, watch hearings live. If you click on that now, it's going to say they're offline. But if you click on it Wednesday at around 12:30, I think that's where it would be live streamed. Oh, wow, Michael, thank you for being a member of the channel. I appreciate your membership so much. Please, again, just the facts, Miller Time. We deal with just the facts, ma'am. Just the facts, sir, right? Facts and only the facts. So the consensus is, I think that we're 50-50 split here in trying to read Judge Stephen J. Hippler. If it's going to be a yes, it's granted, it's denied regarding the motion to continue. Those are the words that I want you to listen for on Wednesday. If he makes a ruling from the bench, granted, denied, and watch him, he might throw out some, he does it all the time. He'll throw out some information, some body language, a few words here, a few words there that might tell us a little bit about where he's leaning possibly on the offers of proof as to alternate perpetrators. And again, more than one. If you look at the documents, you're going to see that the defense has always referred to them as more than one. Okay, special prosecutor needs to finish before trial can start. Carmen Payette making a good point. Special prosecutor needs to finish the investigation before the trial. A lot of people feel that way. A lot of people feel that way. Okay, if there's no other questions as of right now, I know that it is Father's Day for the fathers out there. It is Sunday, still the weekend here in the US, getting into the evening, I believe, for those of us that are here from the other side of the pond, if you will. I'd like to go ahead then and sort of end this live. We'll probably be doing another one if let me rephrase that. If the motion to continue is denied, we'll probably do another live next month in July or sooner, as situations and it seems every day something's coming up lately. We'll do another live before the trial. Definitely first day of trial. We're doing a live. We're going to go the first time we're doing that. Have to do it. We need to be there for opening arguments. We need to be there for when Hitler talks to the jury for the first time. We need to be there to see what the state's going to say. I'm predicting it's going to be Bill Thompson who will be giving the opening statements at trial. And I'm predicting that it will be Ms. Taylor on the defense side. Wanda Woman, thank you so much. I will. Thank you. I will have some coffee right after I end this live. Thank you. So we'll do another live before the trial if the motion to continue is not granted. We will definitely be there first day of trial, maybe beyond that if situations warrant it. Until next time, please keep watching the channel, keep updated. We're going to keep updating you on the podcast. I'm anticipating something being published tomorrow, Monday, in anticipation of the hearings. If and when it hits the docket, we will let you know. On the podcast just says Idaho versus Kohberger. It's only oral. Sometimes we throw up on the YouTube channel looking at the documents. You'll see something a little longer, 8 minutes maybe. We don't go very long, so that you can take the rest of your time and look at the documents, as I know you're capable of doing. All right, everybody. Miller time, thank you. Down the rabbit hole, thanks for being here. Amy, thank you. I can't thank you enough. Yvonne, all the new members, all of the new supporters, thank you so much. And we will see you again soon. Bye, everybody.